Hello everyone, I am Akshara and today we will discuss Article 26 of the Constitution of India. Have you heard about the Tandav dance? Did you know that the practice of the Tandav dance was also challenged in the Supreme Court? Yes, Tandav dance, composed of followers of the Anand Marg carrying live snakes, skulls, tridents and knives in a public procession, was challenged in the Supreme Court of India because of the dangers it poses to the public. It was challenged in the Supreme Court to ascertain whether it is an essential practice of the Anand Marg order. The Supreme Court held that the Anand Marg order was founded in the year 1955 and it was in existence without the Tandav dance for 11 years, that is until 1966, when their then spiritual leader Sri Anand Murthy introduced it into their religious order. Therefore, the court concluded that since the Tandav dance was not the core upon which the order was founded, it cannot be considered as an essential practice. Following the judgment of the Supreme Court, Sri Anand Murthy inserted Tandav dance as an essential practice in the 1986 edition of the Karya, which is their religious text. On the basis of the said amendment, the Anand Margis sought the permission of the Commissioner of Police to conduct the Tandav procession. The Commissioner of Police allowed the procession provided that the followers would not carry tridents, skulls, snakes or knives in the procession. However, the order of the Commissioner was challenged before the High Court. The High Court decided in favour of the Anand Margis. Subsequently, the decision of the High Court was challenged before the Supreme Court. The Supreme Court once again overruled the decision of the High Court and held that Tandav dance is not an essential practice of the Anand Marg order. It also laid down the following tests to determine what are the essential practices of a religion. The court held that essential parts of a religion means the core beliefs upon which a religion is founded. Essential practice means those practices that are fundamental to follow a religious belief. The test to determine whether a part or practice is essential to a religion is to find out whether the nature of the religion will be changed without that part or practice. If the taking away of that part or practice could result in a fundamental change in the character of that religion or in its belief, then such part could be treated as an essential or integral part. There cannot be additions or subtractions to such parts because it is the very essence of that religion, and alterations will change its fundamental character. The alterable parts or practices cannot be regarded as the core of a religion and therefore must be treated as mere embellishments to the essential tenets of the religion. The essential practice doctrine was recognized and propounded by the Supreme Court in the above case and was recognized for the first time in the year 1954 in the Srirur Mutt case to ensure that the right of religious denominations to manage their own affairs is enjoyed harmoniously with other fundamental rights, including Article 25. It is quite interesting to note that the right of individuals to profess, practice and propagate religion under Article 25 of the Constitution of India is subject to public order, morality, health and other fundamental rights. However, the right of religious denominations to manage their own affairs under Article 26 is subject to public order, morality and health, but not other fundamental rights. This gave rise to a misconception that the right enjoyed by religious denominations under Article 26 is an isolated right. But the Supreme Court has time and again bowled out this view to ensure that the right given to religious denominations is enjoyed harmoniously with other fundamental rights. The interplay of Articles 25 and 26, that is, the individual's right versus the denomination's right, can be understood by looking at the following examples. In Venkataramana, Devaru and others versus State of Mysore and others, the substantial question of law before the 5 judges was whether the right of religious denominations to manage its own affairs in matters of religion guaranteed under Article 26B, was subject to a law protected by Article 25(2)(b) of the Constitution, which provides for social welfare and reform by allowing all classes and sections of Hindus to enter Hindu religious institutions of a public nature. The Sri Venkateramana Temple, situated in Mulkipeta in the state of Mysore, exclusively belonged to the Gauda Saraswat Brahmins living in 3 regions in Mulki. However, an act passed by the Tamil Nadu government called the Madras Temple Entry Authorization Act of 1947 removed the disabilities of the excluded members of the community to enter Hindu temples in Tamil Nadu and offer prayers. That is, now all members of the Hindu community could enter all temples situated in Tamil Nadu, irrespective of their castes. Apprehending the application of the said Act over the exclusive right of the Gauda Saraswat Brahmins to access the Sri Venkateramana Temple, this petition was made before the Supreme Court. The Supreme Court held that the right of denomination to exclude all members of the public from worshipping at the temple is not maintainable, and therefore the social reform mentioned under Article 25(2)(b) would prevail. That is, the temple would be open for public entry and worship. However, with regard to the right of the denomination to exclude members of the public from attending certain religious services, the court upheld the right of the denomination because in doing so, the right of the public would not be limited to enter and worship at the temple at other times. An example of when the individual's right came in conflict with the denomination's right was in Shaira Banu versus Union of India in the year 2017. Shaira Banu was married to Rizwan Ahmed for 15 years when in 2016 he divorced her by instantaneous triple talaq. Talaq-e-biddat, commonly known as triple talaq, was a practice permissible among a large section of Indian Muslims. It gave a man the right to divorce his wife by uttering talaq 3 times in one sitting without her consent. The constitutionality of this practice was challenged by Shaira Banu in Supreme Court of India in the year 2017. Justice Kurian Joseph, who was in the majority, held that the practice of triple talaq failed the test of essentiality. He relied on a 2002 Supreme Court judgment which held that any practice which does not conform with Quranic teachings cannot be an essential tenet of Islam. In Quran, the practice of divorce is permissible only if there is reasonable cause and is preceded by attempts to reconcile the parties by their families. A divorce can be effected only if these attempts fail. Even though divorce is permitted, it is considered sinful and therefore undesirable. The court held that the practice of triple talaq is therefore bad in theology and also bad in law. The majority also held that just because customs and usages have been permissible and practiced for centuries, it does not by that virtue alone become an essential tenet of a religion. The court therefore held by a 3:2 majority that the practice of triple talaq is unconstitutional. Concluding the video, we have understood that the Supreme Court has repeatedly interpreted the right of the denomination to manage its own affairs in matters of religion, guaranteed under Article 26 to enhance the right of the individual to worship in the community. Therefore, the courts have struck a balance between the denomination's right, the individual's right, and the right of other members of different communities. The courts have been mindful not to expand the purview of the right to freedom of religion so broadly that they become absolute. In doing so, the courts have ensured that the freedom of religion for both the denomination and the individual is not absolute but is subject to reasonable restrictions. Some experts have argued that the essential practices doctrine is problematic and needs to be relooked because the courts may not be competent in matters of religion to decide which practices are essential and which ones are not. However, the intention of the courts in propounding the essential practices test has been to strike a balance between the multitude of rights given to individuals and religious denominations under Part 3 of the Constitution of India, and to ensure that these rights are enjoyed harmoniously and not in isolation from one another. Thank you for watching this video. This presentation is part of a series of videos explaining the law on freedom of religion in India. Please like and share this video and subscribe to the ADF India YouTube channel.